the President on the potential invocation of privilege, which is consistent with long-standing practice. Following that review, the President confirmed that in the interest of transparency and full disclosure to the American people, he would not assert privilege over the special counsel's report. Accordingly, the public report I am releasing today contains redactions only for the 4 categories that I previously outlined, and no material has been redacted based on executive privilege. In addition, earlier this week, the President's personal counsel requested and was given the opportunity to read a final version of the redacted report before it was publicly released. That request was consistent with the practice followed under the Ethics in Government Act, which permitted individuals named in a report prepared by an independent counsel the opportunity to read the report before publication. The President's personal lawyers were not permitted to make and did not request any redactions. In addition to making the redacted report public, we are also working with Congress to accommodate their legitimate oversight interests with respect to the special counsel's investigation. We have been consulting with Chairman Graham and Chairman Nadler through this process, and we will continue to do so. Given the limited nature of the redactions, I believe that the publicly released report will allow every American to understand the results of the special counsel's investigation. Nevertheless, in an effort to accommodate congressional requests, we will make available, subject to appropriate safeguards, to a bipartisan group of leaders from several congressional committees, a version of the report with all redactions removed, except those relating to grand jury information. Thus, these members of Congress will be able to see all of the redacted material for themselves, with the limited exception of that which, by law, cannot be shared. I believe that this accommodation, together with my upcoming testimony before the Senate and House Judiciary Committees, will satisfy any need Congress has for information regarding the special counsel's investigation. Once again, I'd like to thank you for being here, and I will now have a few questions.
Mr. Attorney General, we don't have the report in hand, so could you explain for us the special counsel's articulated reason for not reaching a decision on obstruction of justice, and if it had anything to do with the department's long-standing guidance on not indicting a sitting president? And you say you disagreed with some of his legal theories. What did you disagree with him on?
I'd leave it to his description in the report, the special counsel's own articulation of why he did not want to make a determination as to whether or not there was an obstruction offense. But I will say that when we met with him, Deputy Attorney General Rosenstein and I met with him, along with Ed O'Callaghan, who is the principal associate deputy, on March 5th, we specifically asked him about the OLC opinion and whether or not he was taking the position that he would have found a crime but for the existence of the OLC opinion. And he made it very clear several times that that was not his position. He was not saying that but for the OLC opinion he would have found a crime. He made it clear that he had not made the determination that there was a crime.
Did you disagree with him on?
May I follow up on that, Mr. Attorney General?
What did you disagree with him on?
Given that, why did you and Mr. Rosenstein feel the need you had to take it to the next step to conclude that there was no crime, especially given that DOJ policy?
Well, the very prosecutorial function and all our powers as prosecutors, including the power to convene grand juries and the compulsory process that's involved there, is for one purpose and one purpose only. It's determine yes or no. Was alleged conduct criminal or not criminal? That is our responsibility, and that's why we have the tools we have. And we don't go through this process just to collect information and throw it out to the public. We collect this information, we use that compulsory process for the purpose of making that decision. And because the special counsel did not make that decision, we felt the department had to, and that was a decision by me and the Deputy Attorney General.
Yes. Or did the special counsel indicate that he wanted you to make the decision or that it should be left for Congress? And also, how do you respond to criticism you're receiving from congressional Democrats that you're acting more as an attorney for the president rather than as the chief law enforcement officer?
Special Counsel Mueller did not indicate that his purpose was to leave the decision to Congress. I hope that was not his view, since we don't convene grand juries and conduct criminal investigations for that purpose. He did not. I didn't talk to him directly about the fact that we were making the decision, but I am told that his reaction to that was that it was my prerogative as Attorney General to make that decision.
Attorney General Barb Catherine here at Fox News. Hi there. Is there anything you can share today about your review of the genesis of the Russia investigation and whether assets have been provided to investigate?
No, today I'm really focused just on the process of releasing this report.
Attorney General, senior Democrats in Congress have asked for Robert Mueller himself to testify. Robert Mueller remains a Justice Department employee as of this moment. Will you permit him to testify publicly to Congress?
I have no objection to Bob Mueller personally testifying.
Mr. Attorney General, it's not just Democrats who have questioned some of the process here. A Republican-appointed judge on Tuesday said you have, quote, created an environment that has caused a significant part of the American public to be concerned about these redactions. You clear the president on obstruction. The president is fundraising off of your comments about spying. And here you have remarks that are quite generous to the president, including acknowledging his feelings and his emotions. So what do you say to people on both sides of the aisle who are concerned that you are trying to protect the president?
Well, actually, the statements about his sincere beliefs are recognized in the report, that there was substantial evidence for that. So I'm not sure what your basis is for saying that I'm being generous to the president.
You face an unprecedented situation. It just seems like there's a lot of effort to go out of your way to acknowledge how this.
Well, is there another precedent for it?
No, but it's unusual.
Okay, so
that,
unprecedented is an accurate description, isn't it?
yes. But
Okay.
What do you say to people who are concerned that you are trying to protect the president?
Eric?
There's a lot of public interest in the absence of the special counsel and members of his team. Was he invited to join you up on the podium? Why is he not here? This is his report, obviously, that you're talking about today.
No, it's not. It's a report he did for me as the Attorney General. He is required under the regulation to provide me with a confidential report. I'm here to discuss my response to that report and my decision, entirely discretionary, to make it public, since these reports are not supposed to be made public. That's what I'm here to discuss.
Impropriety for you to come out and sort of what appears to be sort of spinning the report before the public gets a chance to read it?
Okay, thank you very much. Thank you.